A law firm's success is best represented by the results of how they help their clients achieve justice, like in the case of Olga Hernandez.
When the FBI first came to my house, I was just absolutely horrified. Nothing like that had ever happened to me before. When they came, I really believed they were just going to ask me questions about the Mullins group because I knew they had been looked at by the FBI. And I thought it had something to do with their IRS or something of that nature. I had no clue that they were involving me in whatever schemes they were into. They started throwing all these legal terms at me, and I had no idea what they were talking about. When I found out that I was indicted, that was even a worse feeling because, I mean, now we're talking, this is really something, you know. I need a lawyer. They're going to come and arrest me. And I even asked the FBI man when he said that I was going to be indicted. I said, you mean I'm going to be on camera and I'm going to be arrested? And, oh, yes, you know. And then that's when they started talking to me about trying to make a deal. And I said I wouldn't do that because I wasn't guilty. So I was really outraged. This can happen to anyone. Boy, if I hadn't had the lawyers that I had to take care of me, I'd be in prison right now, an innocent person in prison. And it really gripes me to think that there are probably a lot of innocent people in prison right now because they get scared.
And Bill Reed, partner at Reed, Collins & Sy, was Olga's lawyer.
And Mr. Reed, you came all the way from Austin to represent her. You were saying earlier, you said that, you know, the bad things shouldn't happen to good people.
That's what I said.
Explain that.
Well, I used to be a U.S. attorney, and I did this for a living, and I haven't done this in 17 years, coming to a criminal courtroom in the United States. And what I asked this jury to do was to protect a brave woman from the federal government who made a mistake. And people make mistakes, that's okay. But we, the citizens, need to stand up to the government when they make a mistake, and this brave woman did it, and we all stood behind her.
Yeah. Since 2009, Reed, Collins & Sy has become legendary in the legal world as the Special Forces team for complex litigation, achieving billions of dollars of settlements and judgments. They've set valuable legal precedents to protect investors and hold wrongdoers accountable. The firm is widely recognized by industry observers for its achievements, but their amazing reputation is based on the vision of what justice should and must be. And two of their founding partners, Bill Reed and Lisa Sy, share their vision with you now.
I think justice means getting your day in court. I think it means getting a recovery when somebody has wronged you. And it means having somebody standing by your side who's fighting for you, who is advocating for you competently and ethically to where your voice is being heard. And part of my view, I'm sure, is colored by the fact that I'm a plaintiff's lawyer, but in my mind, that's where the battle for justice is can folks who've actually been wronged get redress for the harm that's been done to them.
There's no one-size-fits-all definition of justice. Sometimes justice is getting the right compensation to a wronged victim. Sometimes the plaintiff isn't really the framework through which I look at justice. It's more, does this defendant need to pay so this defendant won't do whatever it is they did again? And I'm more focused, generally speaking, on making the defendant pay than really focused on who our client is, because candidly, when an individual is our client, that's when I focus on getting that individual compensation. When a hedge fund's our client, or a bankruptcy trustee who's just getting paid an hourly fee on behalf of a bunch of financial creditors, really justice from their vantage point isn't nearly as important as it is from the person that we're suing.
When we take on clients, our first and foremost priority is getting the maximum recovery, solution, benefit, whatever it is that we can for that client in their situation. We take on clients who we believe in. We take on clients who have problems and issues and causes that we think are worthy, where we have vetted it and we feel that, again, there is something rotten in the state of Denmark, and we as plaintiffs lawyers sitting in our shoes with our skill set and our experience can help them with. That's what we're trying to do for our clients.
What I see our firm achieving day to day is obtaining a result in the quickest, most efficient way possible, often on a complicated stage. I've referred to it as a multidimensional chessboard. We enjoy playing the game of chess, but it doesn't matter unless you get a result.
What gives me satisfaction, and I would actually call it joy in lawyering, is knowing, really understanding intimately what the impact is of my work. In other words, I am not just a mouthpiece. I am not just a hired gun. I am there to represent somebody. I am their sole voice. There is no one else standing up in that courtroom for them, making those arguments for them. That's what gives me that joy and satisfaction, is knowing I have a job to do that is fundamentally important, not just to that particular case and not even just that client, but ultimately, as I think we've seen in the last several years, it's important, fundamentally, bedrock to our democracy, to what it is that we're trying to do here.
What brings me the greatest satisfaction in all of our cases is looking back on a result and I think oftentimes rightfully concluding, I don't think any other law firm could have done this. Ren's an example of that. Olga Hernandez is an example of that. There are countless examples of that. Credit Suisse as well.
When there are clients who have problems that others have evaluated and turned down and said, there's no way, there's no door, there's no avenue, there may be instances where that's true. But I'm here to tell you, and I think that our firm and some of the cases we have brought are living proof of the fact it is not always the case. And sometimes when a door is shut, there is a window. And I think ultimately, right, the law is not static. I think that's very important to understand. The law is not just some set of principles that never change. The law can extend. The law can be expanded. Every single case, including the cases we bring, push those various corners of the law in those different directions that we as a firm feel they need to be pushed into. And so you got a problem as a client, maybe there's not a case just like yours yet, but maybe your case will be the one.
Go to someone that will fight, go to someone that's creative, and go to someone that only gets in the game to win the game. That's us.
What I would like folks to know and take away about our firm is that we are trying to at least play our part in this justice system to get recoveries for people, for investors, for corporations, when there are wrongs committed, that we are a firm that, frankly, unlike the majority of lawyers you see out there, are actually trying bit by bit to make that difference and be part of what I think is important change, to hold corporations accountable, to hold big institutions accountable, to hold wrongdoers in the corporate space accountable for their wrongs.
So the message that our firm hopefully sends out to the world is that you can create your own path. You can create a law firm in your own vision and make it succeed. And if someone said to us, hey, you know, you're going to start a law firm in Austin, Texas to do financial litigation in every city in the U.S. except for Austin, Texas, and you will get on the national stage and everyone will know who you are, we would all said, you're crazy. And yet, that's where we sit now, 12 years later. And it's really cool to look at what we've created. But the only reason that we were able to create what we did was because of our team. We have an incredible team, from our staff to our paralegals to our lawyers. And every day the team gets stronger. And the people that we're able to attract now, the cases we're able to attract, are exponentially all greater than what we started with 12 years ago. And we're not done yet.
In this insider exclusive Justice in America Network TV special, Justice in America, the Reed, Collins, and Sy story, our news team sits down with Bill Reed, Lisa Sy, and Nate Palmer, partners at Reed, Collins, and Sy, to show how they won major victories in complex business cases like these. A $121 million fraud judgment in Claymore Holdings versus Credit Suisse. $300 million settlement against Renren, one of the largest derivative recoveries in history, and many more. Bill, Lisa, and Nate have earned reputations as unyielding trial lawyers who repeatedly represent clients against big companies and the Goliaths of the world and repeatedly win. They have earned the highest respect from citizens and lawyers alike as some of the best trial lawyers in Texas and across the nation. They have built substantial reputations nationwide by consistently winning cases other law firms have turned down. And their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Austin, Texas. It is my great pleasure to introduce Bill Reed and Lisa Tsai to the show. Welcome to the show.
Good morning.
Thank you.
Tell our audience a little bit about your firm. What type of practice do you do?
I would say we're a plaintiff's trial firm. We bring claims that often would otherwise not get brought against corporate America.
Yeah, and one of the things I noticed is that your firm has sued, I think, 20 of the top 100 big law firms for legal malpractice, right? So you're not a popular guest at Christmas parties with them, right?
Until we're needed.
Tell our audience a little bit about some of the complex litigation cases that you've been involved with.
Well, our firm brings a lot of cases in the context of large financial losses. So we see financial fraud, we see Ponzi schemes, we see malfeasance by directors and officers. We also see professional malpractice, mistakes that are made by various professionals, whether it be law firms or accountants or other folks who may have been responsible for trying to support a business or a company.
Right. What are some of the most common malpractice cases and elements that you see against accounting firms and law firms? Overbilling?
It's not overbilling in the cases that we typically see. There's really two types if you look at legal malpractice. So there's both what happens in the course of large transactions. If you think about how complex, I mean, there are transactions where there's hundreds of millions, if not billions of dollars flowing through. And lawyers, like anybody, can make mistakes. Mistakes, though, that can be very costly. So that's one form of it. Another type can be in the context of a lawsuit, right? There's lawyers who represent, obviously, clients day in, day out. And in the course of that, you may make some sort of mistake. And I'd also say that there can be more sinister activity, of course. There can be lawyers, and frankly, I mean, we saw that in the time of Enron. There have been other instances, but where lawyers in particular had an actual hand in helping the underlying fraudsters or bad actors in committing those deeds.
I think one of the biggest fact patterns that we see in legal malpractice is the multiple client representation, or alternatively, where there's a dominant individual who is in some capacity for a corporation, say, or some other business entity, and the client of the law firm is the business entity, and those entities have interests that are not the same as the individual. And the lawyer can't help in dealing with the individual but to look out for that individual, even if that individual is not their client. And so the guy writing their checks or the gal writing their checks and taking them to dinner may want a certain course of action which could be harmful to the entity that's the client. And these are the sorts of fact patterns we see where lawyers don't even understand that they're doing something wrong, but from the vantage point of their true client, the entity, oftentimes they are.
Yeah, you know, some of the cases that come to mind when we were reviewing and preparing for the show was the case of Grey Goose. Tell our audience a little bit about that case.
Well, that's an old one. That's a long time ago. But Bruce Bakerman had been to 7 law firms seeking to get representation to pursue a claim against Sidney Frank Importing Company. And Bruce was the general counsel to Sidney Frank Importing Company, and Mr. Frank, who was a multi-billionaire, had gifted him a 10% interest in Grey Goose Bottling Company. Grey Goose Bottling Company owned the manufacturing facilities in Cognac, France, the recipe, and the distribution rights in places like Australia and certain Asian countries. And Sidney Frank Importing Company owned the distribution rights to Grey Goose vodka in North America and all of Europe except for France. And so the collective assets of both entities were sold to Bacardi for $2.3 billion, and all but $19 million was allocated to Sidney Frank Importing Company. 100% of Sidney Frank Importing Company shareholders represented 90% of Grey Goose Bottling. The only shareholder who wasn't on both sides was Mr. Bakerman. But Mr. Bakerman had signed a consent to the transaction, been paid $700,000, cashed the check, and kept the money.
Yeah, and I want to stop you right there because that was a big problem, right, for other law firms, right? You've already accepted the check, you know, you're done. Well, how did you get around that?
Delaware has a concept of what is called entire fairness. And so if a controlling, doesn't have to be shareholder, but a controlling person who controls an entity makes a decision that is objectively unfair to the minority, in this case, Mr. Bakerman, even if the minority at the time consented to that transaction, they have the right to seek what is called entire fairness review in the Delaware courts. And so it was the critical moment of the hearing. Lisa and I were both there, and it was 2005, so 17 years ago. But the judge asked the question, okay, Mr. Reed, what do you say should have happened in this case? And so I said, Judge, to answer your question, or better yet, Chancellor, to answer your question, I have to go outside the pleadings, and we were on a motion to dismiss, and that kind of violates the rules, but he gave me permission. And I said, well, Judge, really what Grey Goose Bottling had, if it had an independent negotiator, was the right to bargain, to hold out, to stop this transaction unless it was paid a fair amount of money. And everyone could agree that $19 million, which was less than the manufacturing facility cost to build, leaving aside the recipe and everything else, was woefully inadequate. And so I said probably 10 to 30%, somewhere between $230 to $690 million. And Mr. Bakerman would have got $23 to $69 million of that. And so then the judge asked the critical question, why? Why did he do this? And interestingly, every one of the C-suite of Sidney Frank Importing Company had driven from New York to Dover, Delaware in a stretch limousine, and they were in the courtroom. And I went down the list. I'm like, Mr. Einsiedler got $120 million, and Mr. So-and-so got 60, and Sidney Frank secretary got $69 million. So you're asking the question, why is this fair? How could this possibly be fair? How could somebody possibly sell their interest in this whole transaction for a few $100,000 when everyone else made tens of millions of dollars? And it clicked for the judge right there. He's like, okay. And we got a 58-page ruling and settled the case shortly thereafter.
Are you allowed to say what you settled it for?
No.
It was far more than $700,000.
Correct.
Okay, good. You just nailed the facts. That's it. It's logic after that.
I can tell you that Mr. Bakerman retired and has ever since been living in Florida, and I hear from him every once in a while.
One of the other big cases that is an ongoing, almost nightmare of litigation is the Credit Suisse story, right? The case. Lisa, tell our audience a little bit about that.
We have had a decade-long journey of prosecuting claims against Credit Suisse for fraud in connection with their serving as the investment bank, the arranger on a $540 million loan refinance transaction related to this property called the Lake Las Vegas development. It has been a journey. It's one that I think ultimately we're going to get a recovery on. We have a judgment currently for $121 million.
Plus interest.
Plus interest. That ticks at 9% a year. We've had a jury find that Credit Suisse, after hearing 3 weeks of evidence, actually conspired with the appraiser to pump up the value of the appraisal on that property. That appraisal ended up being between $511 and $891 million. Our appraisal expert came in and said, actually, it's short of $200 million. This is how Credit Suisse duped the investors and how our clients ultimately ended up putting in $250 million into this refinancing. Ultimately, we've gone through years of appeals, arguments, briefings, trials, went back on remand, and now we're on appeal again.
Okay, and ultimately you'll end up getting your money. But I just want to ask one question that everybody's asking when they're watching this, is saying, well, why would a bank pump up the appraisal? And Please tell us why.
A story as old as time. I mean, it's human greed ultimately. And I think one thing that maybe people don't always appreciate is that fraud is committed by people, and in that moment, it's all about those folks and their present motives, what is going to presently benefit them. And so a bank is interested in doing that because in this case, the folks who were the investment bankers on this deal, they needed their numbers to look good. They needed to have high year end. They needed to then reap their millions of dollars in bonuses. And in particular, Credit Suisse itself was going to make millions of dollars as an institution, as being the arranger on a deal like this, should it go through. And it went through exactly because of what they did in inflating the appraisal.
It almost reminds me of the 2007, 2008 financial collapse and all these bonuses that were paid to people that, for example, worked at AIG, worked at various other investment banks. No money was ever clawed back. They all keep that money, and that's interesting. Now, a personal case of yours, which you did pro bono, is the Olga Hernandez case. Tell our audience a little bit about the case, why you did it, what happened.
The acquittal occurred in 2018. I think I agreed to represent Olga a year earlier. And my friend, Alan Brown, had come to me and said he had a criminal case and he needed help because he'd received, I think, 200 and some odd audio tapes of supposed recordings, some of which included Olga Hernandez, my ultimate client. So I said, I agree that I will go meet her, but I will not agree to represent her unless I can think I can help her, A, and actually think that she didn't do anything wrong, B. So I met with her, and she showed up with a loaf of bread or some baked product, which she always did, even though I told her I didn't eat gluten. She really impressed me, and more importantly, the story compelled me to help her. And I had been a federal prosecutor in the division in which she was being prosecuted, San Antonio, and I felt like the conduct of both the prosecutor and the FBI was reprehensible, and I wanted to do something, try my best to make it right.
And you did a great job. You got her acquitted. More importantly, I think one of the main reasons is you saw that the government overreached, lack of a better term, they abused the legal process. And the reason I have thought about this case a lot, the reason I see the prosecutors might do that, especially ASUAs, is because they're looking to make that jump into private practice. And if they get the name in the paper, right, with a conviction, especially on a public official, that might allow them to make that kind of jump, right? And more money, right?
I would agree that the AUSAs and FBI agents, particularly this group of FBI agents who were in the, quote, public corruption or public integrity task force, were motivated to prosecute Olga because she was a public official, an elected school board member. I don't know that this AUSA was motivated to go to private practice. In fact, I don't think he'll ever end up in private practice. I think he's pretty worthless as a human being. And I complained about his conduct, which I could go into at length, and my complaint was thrown in the trash.
You had another case that really stands out as you're doing outstanding work at your firm, Merit Management Group versus FTI Consulting. Tell our audience a little bit about that. What was the essence of that case?
So that was also a Credit Suisse syndicated loan, believe it or not, but Credit Suisse was not the target in that case. That case was a fraudulent transfer case, which is common to see in the bankruptcy world, where an entity is paying out money over a period of time, and then when the buck stops and the dust clears, the entity has no money left, and it turns out it was actually bankrupt for years and years and years and insolvent, but yet paying dividends out to its constituents, oftentimes private equity firms and the like. So in Merit Management, we were hired by a trustee to go after these various transfers, and in certain jurisdictions the law was very bad for us, and in other jurisdictions the law had not yet been decided. We went to the client and said, we think we can pursue certain of these dividends in jurisdictions like the 7th Circuit in Chicago, Illinois, and in Miami, Florida in the 11th Circuit, two circuits that hadn't yet decided this bankruptcy issue. We told the client that if we prevail in the lower courts in either one of those jurisdictions, we will likely end up in the U.S. Supreme Court because we will create what's called a circuit split. We won in Chicago, lost in Miami. The 7th Circuit ruled in our favor 3-0, and we took the case all the way to the U.S. Supreme Court and won the issue 9-0, which is a rare thing in the U.S. Supreme Court. So it's a really cool example of how creative we can be in using the procedure to our advantage and then ultimately winning an extremely complicated, arcane issue of bankruptcy law called 546E, the safe harbor. It's called the stockbroker's exemption. But that exemption applies to literally billions of dollars of litigation.
Right. Was Posner on the Seventh Circuit at the time that his decision?
He was, but he was not on this panel. The panel was Easterbrook, Woods, and one other judge.
Now, another case comes to mind, AJW Offshore.
So AJW Offshore was a case for a Cayman liquidator. We represent a lot of Cayman liquidators in U.S. courts. It's one of our cool niche practices. But the facts of AJW were quite interesting to me. The AJW was a fund, and the assets of the fund were a bunch of warrants in stock, thinly traded stock, obscure stock names, in which they would loan money, but they had the right to convert their loans into stock, extraordinary numbers of shares of stock. And the accountants, Markham in this case, did this analysis of how many days at average trading volume it would take to realize these warrants that the company had the right to convert into. In some cases, it was 500 years of actual average trading volume to trade out all of the warrants that the company held, and yet they valued the holdings of this fund at the current value, assuming that all of the warrants could be executed in one day. And the shortest time frame was like 3, 4, 5 years. There were many in like double digits of years. And these accountants signed off on an audit saying that this enterprise had over $500 million in value. You know what the liquidators recovered on that supposedly $500 million pool of assets? How much? 60,000 US dollars. So we sued the accountants, and they lodged a defense called imperi delicto, or imputation, saying that you, the liquidator, are imputed with the bad acts of the former actors on your company's behalf. This guy, Corey Robotsky, who was a bad guy and prosecuted or sued civilly by the SEC, and et cetera, et cetera. And so we overcame that legal defense, and then they were kind of sitting ducks on the facts, as I've explained them.
Congratulations on that. You had mentioned earlier some legal malpractice cases. There's 2 law firms that come to mind. I think you've sued 20 out of 100 of the top corporate law firms. One of them was Reed Smith.
So before we get to that, let me just explain to you, Steve, that probably 80% of our legal malpractice cases never see the light of day, because we deliver a draft complaint to law firms with the invitation to have a business discussion. Most law firms are willing and desirous of having that discussion, and it all becomes a conversation with their insurer. In a few instances, like the Reed Smith case you mentioned a moment ago, we had that process and it failed, and so we resorted to what is the resort in every one of these cases, window number B, which is litigation. So Reed Smith. Reed Smith prosecuted a $500 million some odd underlying case relating to RMBS in the 2008 financial crisis. They prepared a memo in about 2011 saying that they had a statute of limitations that would expire in the next year. They let that window expire, and 2 years later they filed suit and lost on limitations, predictably. So we sued them for the basic negligence of filing the case 2 years late when they had written a memo 3 years earlier, that had they filed their own memo, they would have filed the case timely. It was a pretty straightforward case. Right. But they fought us for a while until they decided not to fight us.
And what about Brown Rudnick?
So Brown Rudnick was a $300 million on the underlying piece of litigation. Both of these cases were litigation malpractice, which is actually a smaller subset. We see more transactional malpractice, busted transactions. But Lyondale was a big bankruptcy in the 2008 financial crisis. It was a chemical company. And the private equity owners, and in fact, this one individual billionaire guy from Europe somewhere, he cashed out, he lent money to the company, and then 7 days later, $300 million, paid himself back. That's called a preference if it occurs in a short time prior to the bankruptcy. In this case, it was 3 months prior to the bankruptcy. Now, Brown Rudnick is supposedly a bankruptcy firm, and this was a piece of bankruptcy litigation that they totally lost because they were unable to prove that the entity was insolvent in October of 2008 when it filed bankruptcy in January 2009. Now, that was quite a turbulent period of the U.S. economy, and it was at least plausible that an entity could be solvent on October of 2008 and 3 months later be insolvent. But the actual balance sheet showed that they were insolvent had the lawyers realized basic financial accounting, which they didn't realize. So there was a $7 billion intercompany receivable, and the entity that paid the $300 million to this billionaire guy was the entity that owed the $7 billion intercompany receivable. For reasons that still elude me, Brown Rudnick attempted to prove insolvency at the holding company level, where that $7 billion intercompany debt basically zeroed out. Because at the holding company level, the $7 billion is owed to it, and the liability of its subsidiary, it doesn't matter at the holdco level. If they had looked at the transfer from the entity that paid the $300 million, they could easily have demonstrated insolvency and won the case.
Lisa, there was another couple of cases, Oric and Bank of Scotland.
That's right.
Tell us about those kind of cases and why they're important to your firm.
We had a set of litigation that arose out of the 2008 financial crisis, and essentially what we figured out is that there had been wrongdoing by both the Royal Bank of Scotland as well as ultimately the law firm that was the transactional counsel on the deal, and that's a law firm very well known, very national, called Oric. But essentially what had happened is there was a collateralized loan obligation, basket of assets, right? This was kind of typical, back in the day, still is, you package up a bunch of assets. Essentially, Royal Bank of Scotland was the bank that was in charge of making the decision as to what happens when there's a shortfall. And what we discovered is that RBS, in contravention of essentially their duties, in contravention of what they were telling our folks, our clients, they foreclosed on a bunch of these assets. They took them for themselves, essentially, and instead foisted all of the loss from that foreclosure sale onto our clients. Because again, right, these kinds of things only happen when there is some sort of weakness in the market, right? And that's why you see all of these kinds of fraud cases and other malfeasance arising out of, when everything hits the fan. It's not when things are all rosy. If things are rosy, that case maybe would not have seen the light of day.
What was the end result of the case?
Ultimately, we were able to settle that case. We, typical in our cases, presented the other side. And in that case, we actually had to file a lawsuit because RBS was very aggressive there. They filed a proceeding in London. We then had to file a parallel proceeding here in Texas. There are these things called anti-suit injunctions, essentially where you try to enjoin the other side from filing suit, and then you can also file an anti-suit injunction. So we had some pretty complex procedure happening across the pond and here in the States. And ultimately, after some of that infighting, and frankly, as I remember it, the moment when we said, look, we're ready to take your folks' depositions, was the moment when they really wanted to get the thing resolved and they got serious. And the settlement number's confidential, but let's just say, it was a good number and we were happy with the result.
It is amazing the work that your law firm does with the jurisdictional issues. Most law firms are not going to file complaints in other countries. We're going to talk about another case when we bring on your other partner, Nate Palmer, here about Renren, Chinese companies headquartered in the Cayman Islands. But I'm truly amazed at the grasp of the law that you have to get involved with in order to do battle in various jurisdictions around the world.
When bankers say they, quote, sold things at a loss and go into court and...
That's a lie.
And it's a lie. Generally, it ends up bad for the bank and good for us.
You were being kind when you said, well, it's not exactly fraud, it's theft.
It is. I mean, it's fraud as to RBS, certainly. But with respect to Oric, and that was the other component of that particular situation, they had been the deal counsel. And as to them, it was more a negligent situation. The way they had drafted the underlying documents essentially, in some ways, allowed this misconduct to happen by RBS, or at least it didn't protect against it, let's put it this way, in terms of that foreclosure and how it all went down. But what I was also saying is that Oric, like many law firms, there's always this point in time, right, where you have the ability to kind of decide how you're going to address the situation, where you can either be more forthcoming with the client about what's happened, or you can take the alternate route. And I mean, classically, and not virtually every situation, you see law firms, and not just law firms, but other defendants taking the alternate route, which is when faced with the music, right? People don't cough up.
They don't own up to it.
They run, they hide, they conceal, and I think that's what leads to, whether you want to call that part fraud. I mean, there is a concept of something called fraudulent concealment, but it's certainly running away from your problems, hiding under a blanket. And the reality is a lot of these won't ever see a courtroom because there won't be somebody identifying the problem. But when our firm gets in there, or if somebody has thought, hey, I better at least engage somebody to take a look at this, that's when we're able to hold people accountable.
Yeah, you guys do great work. You have another partner that we're going to bring on right now, Nate Palmer. So let's bring him on right now. It is my great pleasure to introduce another partner here at Reed Collins, Nate Palmer. Welcome to the show.
Thank you.
One of the cases that you are very much involved with Bill, is Ren. What does that mean? And tell us a little bit about the case.
I think it means everyone or every man.
In Mandarin.
In Mandarin, yes. The case was fascinating. It was a publicly traded company based in China, organized under Cayman law, listed in the U.S., and it was a Facebook social media knockoff.
Right. That was what it was meant to be.
That was what it was meant to be.
Came to the United States. They're domiciled in the Cayman Islands, where a lot of Chinese companies are, and they were raised a ton of money. What was it, $700 million?
$777 million, I believe.
And that's where the problems began, right?
That's where the problems began. Social media business didn't do so well. So the founder and some of the original investors took that money and began investing it in other companies.
Here's a question, until I got more into research in this. What's wrong with that?
Nothing's wrong with that, per se.
They have a chunk of money. The original idea is not working well, so now they're making investments in other companies. But they have to notify the SEC that they're doing something a little bit different, don't they?
At some point, yes. At some point, the Investment Company Act would require them to register under that particular part of the securities regulations.
And they became aware of that, didn't they?
I believe so.
But that wasn't a problem, that was an opportunity.
Right, but they saw it as a problem.
It was an opportunity for them.
They wanted to use this whole SEC business as a justification to spin off the assets. Now, in an ideal world, they would have given each individual shareholder their little piece of the spun off assets or registered. Instead, they chose door number 3, which was sell to themselves for $1 billion less than what the stuff was worth.
Right, and they made some pretty good investments, didn't they?
They did.
One of them was what? SoFi, which everybody knows is we have in Los Angeles, the SoFi Stadium, but they are the big student loan company and other loans, right?
Correct.
That investment turned out to be very profitable for them, right?
Well, it was very profitable for Ren, the company. They wanted it to be profitable solely for them. That's what happened.
So what was the end result here?
The insiders took the assets, spun them off, and declared a cash dividend, but they did it at a valuation that undervalued all those assets by at least $1 billion. And they paid that pittance of a cash dividend to all the investors who couldn't participate. And then rather than come up with the money to actually buy those assets for themselves, it was an ingenious plan. They just waived their portion of that small cash dividend and took the shares instead. So they ran away with all the assets in the new company.
Without paying for them.
Now, these kind of cases, as we've discussed with some of the other cases, I brought up earlier, they were Cayman Island based. They said that you have no jurisdiction in suing them, but you proved otherwise. How did you do that?
It was digging into the securities filings and the details in the case. Personal jurisdiction, and especially when you're bringing a derivative case, you have to have jurisdiction not only over the individuals, but also the company. So that's a puzzle to fit together, like who can you get where, and can you get the company there also, or can you get the company and get the people? And different jurisdictions in the U.S. have different answers to that problem. And so I went looking at various, where I had like tangible points, like one of the defendants was located in California. Well, that's a interesting option. But when you go look at the law, just because an individual's there doesn't mean the company's there. And so you look at all the different places. New York is one place where they rejected what's called the fiduciary shield doctrine. And under that doctrine, a company's contacts in a jurisdiction can also be the individual's contacts in that jurisdiction.
If the fiduciary shield law does not apply.
If it doesn't apply. And New York long ago rejected that doctrine. So we were able to look at the transaction and the details of the transaction and see that it had really important connection points in New York. And that's how we were able to get the company, and then because we got the company, we got the individual.
Remember, the people who ran off with the money were the individuals. So if we only had the company, we wouldn't have had a case. We had to have both.
Yeah, and you got this verdict in the state courts in New York.
Settlement,
right? Because they knew they were going to lose anyway. There's another case that I think you were very heavily involved with, GT Advanced Technologies. Tell our audience a little bit about the challenges, what kind of case that was.
That case was a company that manufactured furnaces that grew sapphire. So I didn't even know before we got the case that sapphire could be...
Is this like synthetic sapphire?
So GT made furnaces that grew sapphire. So they put some sort of seed in the bottom of the furnace and they fill it with sand and other components. And then they just heat it to extreme temperature and pressure. And then they do a very specific cool down curve that allows the sapphire to crystallize and grow in these structures. And they call them buells. It's like imagine a giant trash can shape piece of sapphire. And so originally this company made furnaces. And then the CEO of the company had the idea of, well, what if we got Apple to adopt sapphire for screens on phones? They use sapphire on watches because it's highly scratch resistant, impact resistant. It's a great material. So they decided they were going to try and get Apple to do it on iPhone screens. Well, the problem was the company wasn't a manufacturer of the sapphire. And to do this, they needed to grow just incredible quantities of sapphire at prices they had never gotten it down to, right? They needed to be so low per screen to compete with what's on them now, Gorilla Glass. So the company went into negotiations with Apple, got a contract with Apple, and then shortly after went into bankruptcy because they just couldn't produce at the price they said they could. And what I ended up, once we got the case, dove into the models, and that was where we started figuring out the case, was when they were in negotiations with Apple to make this work, they had to change all the assumptions in their models. So Apple kept coming back and saying, no, that price isn't going to work. No, that price won't work. And the company kept coming back with a new model that said, okay, well, we can produce it for this much per screen.
Wasn't there an issue about the volume too? That they couldn't have met the volume that they were committing to?
Historically, the volume, the price, the yields, just none of it had any basis in history, but they kept tweaking the model, and then they went to the board and said, oh yeah, we can do this.
The two people that were orchestrating this scheme at the same time were selling their stock into the market. Mm-hmm. So by announcing this deal, the stock value went up. They sold their stock, got like millions of dollars.
Pump it down.
You could argue that. And so one of the claims that we brought, in addition to a breach of fiduciary duty, was to try and get back the profits that they had made based on these lies. So corporate America is oftentimes incentivized to do the wrong thing to make money for themselves, even if it means that the entity suffers in the end.
Well, that was an outstanding case. Your firm has handled a lot of complex cases. I've learned a lot, just by examining and reading some of these cases. And as I mentioned to you, Bill, before, a lot of law firms wouldn't take these cases. You really have to be a kind of a Sherlock Holmes to really investigate, the details. But the overriding theme, I think, in all of these cases of quote-unquote fraud is that someone personally is gaining, right, by screwing over the people that should participate in the profits too, correct?
Unfortunately, that is often the case.
All right, very good. Well, I want to thank you for being on the show. Keep up the good work.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.